Dear all, I am glad that we can see each other again in a new video. And today I am going to talk about civil law. This is the second video. The first one was about criminal law. And now I'm going to deal with contracts. For instance, she practices civil law and spends most of her time making and checking contracts. An article is a section in a contract. For instance, I can say in Article 7, it says that you have to notify the company 2 weeks before you intend to quit. An agreement is a negotiated or legal understanding between two or more groups of people. And we can say that we've finally come to an agreement. Please make the changes in the contract and we'll sign it tomorrow. Liable means when somebody is legally responsible for something. For instance, our company is liable if something goes wrong with the new model. Consideration. Every contract must contain something of value for both parties or both sides, and this valuable issue is called consideration. Let's talk a bit about properties. The landlord is the owner of a rental property. For instance, I can say, my landlord is very helpful. I'm very fortunate because when the washing machine broke, he bought a new one for the apartment by the end of the week. The tenant is the person who's renting the property. And I can say, I've been a tenant in this building for 2 years. A rental agreement is a contract for renting a property without a set amount of time. And I can say, I signed my rental agreement today, but I am not sure for how long I'll be here. Maybe just a few months. A lease is a formal agreement letting someone other than the owner use a property for a certain amount of time and for a certain amount of money. So I can say that I signed a 2-year lease for the apartment. I can't wait to move in. Well, I cannot move in unless I pay a security deposit, which is a payment you make when you rent a property to cover any possible damages that might occur. So I had to pay first month's rent, last month's rent and a security deposit, but now I have the keys to my new apartment. Talking about English used in legal contexts, I have here a short example in which we have some rules. Never choose simple words when complex ones will prove reasonably practicable instead of do. Or never use one double negative where no triple negative will not prove unnecessary. Right. So I will let you read the rest. But here I have a word which is a good example. Hereinafter, a term used in contracts that means further on in the document. Bob's computers will be referred to as Company A, and Joe's electronics will be referred to as Company B hereinafter. When we look at the poor 3 little pigs who are being sued, we see that they might have a solution in an accord and satisfaction, which is a method of discharging a claim upon agreement by the parties to give and accept something in settlement of the claim, something different from or less than that which the creditor is claiming or entitled to. The accord is the agreement, and the satisfaction is the execution and a new contract. For example, if a person is going through a divorce and he is threatened with a lawsuit, he is unable to deal with more legal issues. So, the divorcee talks to the other party and offers to pay a small fine. After both parties sign the statement and the amount is paid, the accord and satisfaction is complete. In other words, if the other person threatens to sue, the divorcee would show the accord and satisfaction to a judge, and the judge would not allow any more money to be collected. We have some other words like DUI, which is the abbreviation for driving under the influence, or DWI, which is the abbreviation for driving while intoxicated. And both terms refer to the offense of driving a vehicle after consuming alcohol. The slang term for this is drunk driving or drink driving. I'm going to tell you a very short story about Sally, who started her own catering business, and this turned out to be lucrative. Later on, a larger company suggested merging, and she was interested. As it was actually a takeover, they needed to settle several details, but they finally reached a compromise, and they hammered out a deal. In other words, they talked seriously and in detail until a business agreement is made. So I let you read the explanation of these words, and I have to go on to the next one, which is loan. As you can see, in order to secure a loan, you need more than $1 million smile and a heart of gold. We need some collateral. So what a loan is, a loan is money borrowed from a bank or private institution that must be paid back with interest. For instance, I can talk about taking a loan when I go to college or when I buy a house. Now, a mortgage is a legal agreement from the bank that lends you money to buy a house. I just bought my first house and have a 30-year mortgage. Collateral, as we have seen, is something pledged as security for repayment of a loan, and it is to be lost or forfeited in the event of a default. We have the verb to default on, which means not to make payments on a loan or mortgage, and it is often used in the past tense, as in the example, he lost his job and defaulted on his mortgage payments. He may lose his house. So a default is the failure to pay back the loan. This is the noun, and as you could see, we also have the verb. Collateral damage is an unintentional victim of a conflict who is injured or even dead. And of course, we can talk about collateral damage when we talk about properties as well. Let's talk about a disclaimer, which is a statement that denies somebody's responsibility. And there is really a dilemma, because usually on different drugs or medicines, we have this disclaimer which says that it may cause drowsiness, which means that we shouldn't use it when we drive the car. But if we talk about sleeping pill, then the disclaimer should change, shouldn't it? Let's talk about more serious issues like the due diligence, which means required carefulness or reasonable care. More precisely, it refers to reasonable steps taken by a person to avoid committing an offense or a tort. And it can be a comprehensive appraisal of a business undertaken by a prospective buyer, especially to establish its assets and liabilities and to evaluate its commercial potential. Now, talking about education, as you can see, once you have a legal education, you have to be paid even for an opinion poll. More interesting phrases, more general ones. For instance, I can't see the forest for the trees, which is an expression used of someone who is too involved in the details of a problem to look at the situation as a whole. For instance, the congressman became so involved in the wording of his bill that he couldn't see the forest for the trees. He did not realize that the bill could never pass. Another saying, a golden key can open any door, is the opinion that sufficient money, or the promise of it, will allow the possessor of it to do anything they wish, which is unfortunately connected to a lot of situations in many countries. Let's forget about corruption and talk about estate planning. Poor Snowman has to consider this situation. Now, estate planning is the preparation of tasks that serve to manage an individual's asset base in the event of their incapacitation or death. The planning includes the bequest of assets to heirs and the settlement of estate taxes. Most estate plans are set up with the help of an attorney experienced in estate law. And since we talked about an attorney, we have to talk about money as well. First of all, the contract. A retainer is a contract between attorney and client, specifying the nature of the services to be rendered and the cost of these services. Besides this, we have the fee. The retainer as the fee that the client pays when he or she retains the attorney to act for him or her. For instance, the lawyer set the retainer at $5,000. Your proposal is written with clarity, this cartoon says, and conviction, so it must be sent up to legal for obfuscation, right? In other words, for becoming more unintelligible. Let's see some more words, which are contributory negligence, which applies when your own carelessness contributing to the damage done to you or your property. So when someone suffers damage or injury, their claim for damages may be limited if they have contributed to the harm done through their own carelessness. And we have another term, cumulative preference shares, which are shares which carry forward unpaid dividends. In other words, dividends which were not paid for the shares which somebody possesses. If dividends on these shares have not been paid in previous years, the arrears, that is, money that is owned and should have been paid earlier, must be paid before a dividend can be paid on the ordinary shares. So you must collect money before other people who have collected their money in due time. The last cartoon talks about new words, right? So they have the word and they have to work on a definition for it. Moot. A moot case or a moot point is one not subject to a judicial determination because it involves an abstract question or a pretended controversy that has not yet actually arisen or has already passed, which is the case of this example. Mootness usually refers to a court's refusal to consider a case because the issue involved has been resolved prior to the court's decision, leaving nothing that would be affected by the court's decision. So, the controversy has already passed, And we have such an example of an individual who sues his employer for his termination, for the fact that he has lost his job, he has been fired. But the employer rehires the employee, and the claim becomes moot because the termination has been revoked. Now, I will call it a day. I hope you have found these words interesting, and I can only wish you to work smart and hard.